We are back with Estate Planning Counsel Mitch Mitchell. He's answering all your questions on wills and trusts and estates and all the things. All right, here's this next question, Mitch. If someone's named on my house to get named on my will to get my house, does the person's name also have to be on the deed of the house?
So generally no, because what you're trying to do in your will is to say what happens to your property when you die. So you don't need to do both. Sometimes I mentioned the transfer on death deed earlier. In some states, you're allowed to do something that bypasses probate by naming somebody on the deed to get your house when you die. But you don't need to do both, and really you shouldn't.
Okay. This is an interesting question. Does the will have to be filed with the courts? I know when I first did my will, I had no idea what happened to a will and how it actually becomes like legal. So let's go ahead and explain that.
So your will, while you're alive, it's a private document, gets stored in a safe place. Typically in your home, it's the best place where it won't be lost and it will be easy for your family to access when you're gone. But it does need to be filed with the probate court when you die. And, there's a common misconception that if I have the will and it names me as executor, I can just go ahead and do whatever the will says. The will doesn't have any legal effect until it's been filed with the probate court and the judge says, yes, that's his will. And yes, this is the person who's named as executor, and they have the authority to serve in that role.
And so you physically have to take the will to the courthouse. There's like processing that needs to be done. And then should we expect a certain amount of time before we can actually start carrying out that will?
Yes. So it has to be it's important that the original document gets filed at the courthouse. And then generally within weeks to sometimes a couple months is when, depending upon your state, there might be a hearing where the court considers whether that was the will and whether this person can be executor. So it's not immediate by any stretch of the imagination. Sometimes you can get a quicker hearing if you have an acute need, you need to access assets fast, but generally there's not an express lane for probate. And the very first step is filing that will and then waiting for a hearing to get the judge to sign an order.
I think what everybody's asking now then is like, so then what happens? How do you pay bills and stuff like that in the meantime?
Yeah, and that's where, if there is need for access, then maybe there should be some other account set up where potentially you have somebody who's a co-signer on an account who has, or at least has access to funds another way. So maybe you've left them stuff outside of the will that doesn't need to go through probate where they can have earlier access.
Okay, this person's asking, if I make out a trust and will, do I have to pay to make changes to it later on?
Generally, yes. Lawyers especially will charge you for changes. And online services too, you're paying for the documents to be done once. But sometimes you can pay for a membership where you don't have to pay the same amount every time. So if I'm making a change, it's included in the cost of my membership.
This is probably our last question. If I was left money in a will from an IRA, but am not the beneficiary on the IRA, can I still receive the money?
So I would say probably generally no, because IRAs, they are unlike other accounts where you have the opportunity to make a beneficiary designation, and that beneficiary designation controls what happens. So your will doesn't control what happens to that IRA. Instead, the beneficiary designation does.
The beneficiary on that IRA. Same thing with a 401k?
Yes, same thing.
Same thing with a bank account?
For accounts that have beneficiary designations, think of it as a contract with a financial institution where they're going to pay to whomever you've told them to pay, and how you do that is a beneficiary designation, not your will.
Okay, that is good to know. All right, thank you for your time, your expertise. For sure, we will need to do this again because we have a lot more questions, so we'll have to do that. If you missed any of this, please look in the Two Wants to Know section.